What would you do in this situation? Your client or your prospective client comes to you and she wants to discharge $50,000 in debt. She wants to make it go away. For various reasons, in her case, you have to use the California Code of Civil Procedure 704 scheme. She has two vehicles. One is a Toyota worth $3,400. The other is a Ford worth $6,000, and she owns them free and clear. In order to exempt or protect the equity in one of the vehicles, you have to use CCP 704.101, but that only allows you to protect equity of $3,325. So one of the cars is going to have to be surrendered if she wants to file bankruptcy. So what would you, as the new attorney, do in this case? Well, number one, present the facts to the client and have her make the decision. Yes, it's her case, and she's going to want to make the decision. Now, some people, when you tell them that in order to file bankruptcy, you're going to have to surrender one of your vehicles, they will immediately pick up their belongings and walk out the door because they don't want to do that. But other people might say, you know what? It might be worth it for me to surrender a property that I can't keep or can't protect in order to make the total debt be discharged. So the first thing that I suggest that you do is to allow the client to make the decision. It's her life, it's her property, it's her bankruptcy. Let her make the decision. Number two, once the client makes the decision, be sure to note that in the file, or even have the client sign that he or she has made this decision and what the decision is. Because it's not uncommon in the middle of the case for the client, when the decision starts to go sideways or they start to realize that they're going to have to give up a car, to immediately point to the attorney and say, I didn't say that. The documentation protects you and your firm, and it also protects the client because the client knows what was decided. So document the file with every decision he or she makes. Number three, by discussing the outcomes early in the case, even before the case is filed, the client can start to prepare. So let's say in that situation where she has two cars, she wants to protect one car, the exemption will only allow her to protect one car, and she knows she's going to have to surrender the other car to the bankruptcy trustee for the trustee to pay off part of the debts. If she knows before she files the case, she can start making plans. She's an adult. She can make plans. She can make plans to live using just one car in the family. And she can start to think of ways that she can economize, or maybe take public transportation or borrow a car or something. But we give her the adult option to start to plan ahead, so that when the hearing comes and the bankruptcy hearing comes, she's not surprised or blindsided. That's what giving her the option does. It gives her time so that she can plot her life without this second car. So the practice pointer is this. When you brief your client in the initial intake and there's bad news to be given, have the client decide what to do. That way you can ethically represent to your client, you can represent to the court, and you can represent to yourself that you have done the right thing. You've explained the situation. The client now owns the situation. Document your file just in case, and then the client can live with the options given and can make plans. This way, you and your client will be on the same page when you go to see the bankruptcy trustee.